is being given to the Parliament.
ये तो आप repeat ना करो ना,
जी,
point
इसमें, तो hence subject to law, and for that I want to take you, my lord, I have placed certain case law before lordship, if my lord has that.
जी दीजिए,
जी।
दे दिए या देंगे?
ये रखे हुए हैं सर,
पहले से नहीं दिए
सर, दिए हैं, बहुत पहले से दिए हुए, रखे हुए हैं।
आज
नहीं सर, मतलब उन्होंने कहा जब आप आर्ग्यू करेंगे उस वक्त दीजिएगा, मैं तो कब हर रोज लेके आ रहा हूँ सर।
सॉरी, दिस इज मोस्ट अनफेयर। हमने कहा था लोगों को फाइल कर दें,
तो ये केस में
हाँ ठीक है, यू आर राइट, वी आर रॉन्ग।
नहीं सर,
वी हैव टोल्ड एवरीबॉडी टू फाइल। हाँ भी कागज के टुकड़े आ रहे हैं बीच में से, और ये कोई आसान चीज है पढ़ना?
इस लॉ है सर, इसमें
तो पहले नहीं कर सकते थे फाइल? इन दुनिया में ऐसे होता है या सिर्फ निजाम अदल में ऐसा चलेगा? बाकी दुनिया की हम तारीख में बताते हैं। ये जरा प्लीज ठहर जाइए ना कि अमेरिका में क्या होता है, विलायत में होता है। आप ये करें अमेरिका विलायत में जाकर के, फिर क्या होगा आपके साथ? वहां तो आप सारे वेस्टर्न ट्रेडिशंस बताते हैं, इस्लामिक ट्रेडिशंस तो बताते नहीं है। अगर कागज के मामले में ठीक है भाई, मेरी मर्जी जब मैं करूं। सच ए सीनियर काउंसिल।
माय लॉर्ड, मे आई टेक पेज 144 ऑफ दिस इज अ केस।
आप हमें प्रोपोजिशन बताएं, पहले प्रोपोजिशन बताया जाता है।
how a subject to law has to be interpreted, that is my।
ठीक है, बता दें कि इसका नंबर।
case is page 144 of this booklet, sir.
जी।
Winberry versus Salisbury. It's a case from the American jurisdiction, and they have interpreted this word, what is the meaning of, and their constitution also provided this thing.
Their constitution also permits of documents in courts. चलिए खैर, 144.
Sir, this is just a case law which I'm citing.
ये सुप्रीम कोर्ट का
नहीं sir, it is Supreme Court of New Jersey, sir.
अच्छा ठीक है
जी। My lord, page 145, if my lord kindly sees the sixth line from the top.
देखिए, वो जरा मुनासिब नहीं लगता है। सुप्रीम कोर्ट ऑफ पाकिस्तान फुल बेंच में, सुप्रीम कोर्ट ऑफ न्यू जर्सी का जरा ठहर तो जाइए ना। हमें हमारा लेवल इतना नो तो ना कर दें। सुप्रीम कोर्ट ऑफ अमेरिका तो बताए, सुप्रीम कोर्ट ऑफ न्यू जर्सी को हम फॉलो करेंगे।
सर मैं सिर्फ बता रहा हूँ कि
हाँ बता दें, जबानी बता दें, आपकी बात में ज्यादा वजन है बल्कि सुप्रीम कोर्ट ऑफ न्यू जर्सी में।
उनके कॉन्स्टिट्यूशन में इस तरह का लफ्ज नहीं है, लेकिन उनके जो स्टेट्स हैं उनके कॉन्स्टिट्यूशन में इस तरह के लफ्ज हैं। Kindly see, the Supreme Court shall make rules governing the administration of all courts, state, and subject to law the practice and procedure of all such courts. This is the law which they interpreted. And my lord, it says, para 2 on page 145.
The phrase subject to law.
The phrase subject to law is not only ambiguous but elliptical. No
what is elliptical mean?
Sir, matlab ki it is confusing.
Ji. You're reading a word. You tell us the meaning of the word.
Continuous, sir. Continuous. No word in the law has more varied meaning than the term law itself. Nor is the phrase subject to crystal clear, for the phrase implies a limitation rather than a grant of power. It is argued by plaintiffs subject to statute or legislation.
It is argued. अभी judgment भी नहीं है।
जी आ रहा हूँ sir. If subject to, अब नीचे last paragraph, sir. If the subject were to interpret it to mean subject to legislation, it would necessarily follow that once the legislature has passed a statute in conflict with the rule of court, the rule-making power of Supreme Court will become functus officio. For it would intolerable to hold, as has been suggested to us, that after the legislature has passed an act modifying a rule of court, the Supreme Court might in turn adopt a new rule overriding the statute, and so on ad nauseum. And yet, if subject to law means subject to legislation, any other construction of rule-making power would be in conflict with fundamental rule of constitutional constraint that unless the context clearly requires otherwise, a constitutional grant of authority is to be interpreted as a continuing power. My lord, then the last three lines, page 146. All these
page 147 से पढ़ लीजिए।
जी हाँ, उसमें आ रहा हूँ।
Page 147 last two lines से पढ़ लीजिए।
जी बहुत बेहतर।
वो वही आ रहा है, नीचे आ रहा है।
जी इसमें फिर सर पेज 146 पे
147 की लास्ट टू लाइन से पढ़ लीजिए ना, वो आपको थोड़ा सा उसमें जवाब मिल रहा है।
जवाब आ रहा है कि मैं कुछ आपको पॉइंट आउट करना चाह रहा हूँ कि पेज 146 से लास्ट तीन लाइंस देख लीजिए। मैं सिर्फ जो पॉइंट्स हैं उसको आपको दिखा दूंगा सर। It is conceivable that the people granted continuing power to the courts in all these respects or withheld it with reference to rule making, sir. Then, my lord, page 147.
Last two lines.
If the Raj may amend the rules, or it may decide the extent to which the law division charge shall exercise the powers and functions of other division. It may control the degree to which legal and equitable relief may be in any cause. We think it may be safely and that no such thoughts are ever in the mind of the member of Constitutional Convention or any citizen who voted for the Constitution. Yet, if subject to law means subject to legislation, such results might inevitably follow. The courts, in some of their essential judicial operations, instead of being one of three coordinate branches of state government, would have been rendered subservient to the legislature in a fashion never contemplated by any. What then is the meaning of subject to law? The only interpretation of subject law that will not defeat the objective of the people to establish an integrated judicial system which is independent and which will at the same time give rational significance to phrase is to construe it as equivalent of substantive law as distinguished from pleading and practice. The distinction between substantive, which defines our rights and duties, and the law of pleading and practice, or through which such rights and duties are enforced in courts, is a fundamental one that is part of daily thinking of judges. Substantive law includes much more than legislation. It comprehends also the rights and duties which have come down to us through the common law. The phrase subject to law in Article 6 of the Constitution thus serves as a continuous reminder that rule-making power as to practice must not invade the field of substantive law as such. While the courts necessarily make new substantive law through the decision of specific case in commonwealth, they are not to make substantive law wholesale through the exercise of rule-making power. That is the concept. So subject to law does not give power to legislate. It is not subject to legislation. Where it is made subject to legislation, then the Constitution uses the words. Make such, as pointed out. ये कई articles हैं of the Constitution, मैंने 154, 150, then 140,
Don't repeat.
240, 241 and 242 के अंदर भी यही लफ्ज हुआ है, make by
Mr.
law.
Abid, the law which is in dispute has been made pursuant to Article 175(2).
Yes, I'm coming,
This
sir.
is the power of the
Sir,
judicator.
but utmost
So,
respect.
in the law itself, pursuant to Article 175(2),
Read
read with Article
Article
191.
191. Article
So we
191.
are making much time on 191. What about Article
I'm coming to that.
175(2)? Because
I'm
no
grateful to
court has jurisdiction unless conferred by the Constitution or the law.
Yes, but 175(2) cannot be read in isolation. That is
No,
the
no,
judgment of
it
this
is,
court.
it is the dedicated to the judicator.
Sir, may I please
So
submit?
power of the court are covered under Article 175.
Read with Article
Read
142.
with, that is the law that have made under pursuant to 190, read with 191.
Yes,
but the law has been made pursuant to Article 175.
My lord,
उसको पढ़े ना 2 में आपके वो
जी, हाँ।
jurisdiction,
जी।
किसी कोर्ट का jurisdiction जो है, that is related and based
इसका
on
मतलब
the
फिर
premise of
जी, बिल्कुल आप
Article
सही कह रहे हैं।
175(2).
My lord, then provincial law भी आपके लिए
कोई भी
province
है,
बना
the
सकता है.
courts 175, there
Two.
shall be a Supreme Court of Pakistan, a High
जी.
Court for each province.
And such a
and
court
the
as
High
may be
Court for
established by
Islamabad.
law. In no court, number
Article 2,
G,
no
no
court
court shall have any jurisdiction save as is or may be conferred on it by constitution by or under any law. That is synonymous. But humble submission is that if this honorable court has interpreted when it deals with the Supreme Court, it has to be read with 2 further articles, Article 142A and Entry 55. May I take your lordship to Article 142A?
Yes.
And that is the judgment of this honorable court, sir.
So this article, I don't
It's
understand.
not a standalone article, sir.
It is?
does no.